Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today we are going to be providing a lecture on a topic that I am so excited to provide and bring to you because it's one of my personal favorite documents from history. And the reason it's one of my favorite documents from U.S. history is it's so clear and it's so direct from one of the most, I would argue, the most consequential individual as it pertains to the Union, to these United States of America, to the 13 states, to the 13 colonies, to independence and liberty writ large. That document that I am specifically referencing today is Thomas Jefferson and the Kentucky Resolution of 1798. Thomas Jefferson, for those of you unfamiliar, was the author of the U.S. Declaration of Independence. So when I ask you, what is the founding document of the Union, I sometimes get the answer, it's the U.S. Constitution. On rare occasions, I even get the Articles of the Confederation, but rarely do I get the U.S. Declaration of Independence. And what we should remind ourselves is that the U.S. Declaration of Independence is the entire reason, is the entire purpose. Well, not purpose, but is the medium by which the Union was even ever able to be formed. If it weren't for the U.S. Declaration of Independence, even if it weren't written by Mr. Thomas Jefferson, the U.S. Constitution couldn't have come about. The 13 states couldn't have unified or unionized. The Articles of the Confederation wouldn't have come about, and the 13 states couldn't have confederated. So this man's opinion, this man's positions, this man's authority is very, very, very consequential and very well worth the high standard that it frequently is placed. So let's see what he has to say in this Thomas Jefferson and Kentucky Resolution of 1798. It says, resolved that the several states composing the United States of America are not united on the principle of unlimited submission to their general government. Wow, that alone, pretty compelling. But that by a compact under the style and title of a Constitution for the United States and of amendments thereto, they constituted a general government for special purposes, delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government. And that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. That to this compact each state acceded as a state and as an integral part, its co-states forming as to itself the other party, that the government created by this compact was not made the exclusive or final judge of the extent of powers delegated to itself. So next time you hear, what is it? Supposedly formed by judicial review, formed by Madison and Marbury, which when you read that case, it actually doesn't form that. But of course, the court's going to rule whatever it needs to get more power, just like what Jefferson is saying here. Whenever you hear that, remember this. The U.S. is not the final authority. The U.S. government and its courts is not the final authority in determining what's constitutional and what isn't. The states are. And that's per the author of the U.S. Declaration of Independence. So if you're going to call me a traitor, go ahead and call Thomas Jefferson a traitor. If you're going to say that my words and my speech is treasonous, go ahead and call Mr. Jefferson treasonous and seditious. All I'm doing is echoing his art, his brilliance, his pennies. Final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution. There it is. The measure of its powers. But that is in all other cases of compact among powers having no common judge. Each party has an equal right to judge for itself, as well of infractions as of the mode and measure of redress. 2. Resolved That the Constitution of the United States, having delegated to Congress a power to punish treason, counterfeiting the securities and current coin of the United States, piracies and felonies committed on the high seas, and offenses against the law of nations, and no other crimes whatsoever, and it being true as a general principle, and what of the amendments to the Constitution having also declared that, quote, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people, end quote. Therefore, the act of Congress passed on the 14th day of July, 1798, and entitled, oh, Caleb, it's so bad for you to misspell. Well, Thomas Jefferson, evidently. Anyway, I digress. And entitled, quote, an act in addition to the act entitled an act for the punishment of certain crimes against the United States, end quote. As also the act passed by them on the day of June 1798 entitled, quote, an act to punish frauds committed on the Bank of the United States, end quote, and all their other acts which presume to create, define, or punish crimes other than those so enumerated in the Constitution are altogether void and of no force. Imagine if a state did that today. They should. They absolutely should. Every state absolutely should. But this is incredible. One of my favorite documents. And that the power to create, define, and punish such other crimes is reserved and of right appertains solely and exclusively to the respective states, each within its own territory. 3. Resolved, that it is true as a general principle, and is also expressly declared by one of the amendments to the Constitution that, quote, the powers not delegated to the United States by the Constitution or prohibited, yeah, it's supposed to say or prohibited by it to the states are reserved to the states respectively, or to the people, end quote. And that no power over the freedom of religion, freedom of speech, or freedom of the press being delegated to the United States by the Constitution, nor prohibited by it to the states, all lawful powers respecting the same did of right remain and were reserved to the states or the people. That thus was manifested their determination to retain to themselves the right of judging how far the licentiousness of speech and of the press may be abridged without lessening their useful freedom, and how far those abuses which cannot be separated from their use should be tolerated, rather than the use be destroyed. And thus also they guarded against all abridgment by the United States of the freedom of religious opinions and exercises, and retained to themselves the right of protecting the same, as this state, by a law passed on the general demand of its citizens, had already protected them from all human restraint or interference. And that in addition to this general principle and express declaration, another and more special provision has been made by one of the amendments to the Constitution, which expressly declares that, quote, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, thereby guarding in the same sentence and under the same words the freedom of religion, of speech, and of the press, insomuch that whatever violated either throws down the sanctuary which covers the others, arid that libels, falsehood, and defamation, equally with heresy and false religion, are withheld from the cognizance of federal tribunals. That therefore the act of Congress of the United States passed on the 14th day of July, 1798, entitled an act in addition to the act entitled an act for the punishment of certain crimes against the United States, which does abridge the freedom of the press, is not law, but is altogether void and of no force. This is what nullification sounds like and looks like. Do you prefer this, or do you want civil war? Number 4, resolved, that alien friends are under the jurisdiction and protection of the laws of the state wherein they are, that no power over them has been delegated to the United States nor prohibited to the individual states distinct from their power over citizens. And listen, I know some of you, probably a lot of you, are going to disagree with that because you want these sanctuary cities dealt with. Please understand the implications of giving the U.S. government that authority. If you allow the U.S. government to determine who is and who isn't a citizen, you give the U.S. government reign over everyone. And that very quickly devolves. If you would like further explanation as to how and how quickly that devolves, let me know in the comments and I'll gladly oblige. History has provided plenty of examples of how quickly and how severely that devolves. nor prohibited to the individual states distinct from their power over citizens, and it being true as a general principle, and one of the amendments to the Constitution having also declared that the, quote, powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people, end quote. The Act of the Congress of the United States passed on the day of July 1798 entitled, quote, an act concerning aliens, end quote, which assumes powers over alien friends not delegated by the Constitution, is not law, but is altogether void and of no force. 5. Resolved, that in addition to the general principle as well as the express declaration that powers not delegated are reserved, another and more special provision inserted in the Constitution from abundant caution has declared that, quote, the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808. That this Commonwealth does admit the migration of alien friends described as the subject of the said act, of the said act concerning aliens, that a provision against prohibiting their migration is a provision against all acts equivalent thereto, or it would be nugatory. That to remove them when migrated is equivalent to a prohibition on their migration, and is therefore contrary to the said provision of the Constitution and void. Gosh. Now we would have to bring this paper before the U.S. Supreme Court and beg them, oh, please, please uphold state sovereignty, please uphold states' rights, when we know for a fact that they wouldn't. And they have never, virtually never, respected or honored state sovereignty, especially when a state tries to go and say, actually, those are unconstitutional, despite what the U.S. Supreme Court says. 6. Resolved, that the imprisonment of a person under the protection of the laws of this Commonwealth, on his failure to obey the simple order of the President to depart out of the United States as is undertaken by said act entitled, quote, an act concerning aliens, is contrary to the Constitution, one amendment to which is provided that, quote, no person shall be deprived of life, liberty without due process of, no person shalt be deprived of liberty without due progress of law. Progress, not process. Interesting. And that another having provided that, quote, in all criminal prosecutions, the accused shall enjoy the right to public trial by an impartial jury, to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The same act undertaking to authorize the President to remove a person out of the United States who is under the protection of the law on his own suspicion, without accusation, without jury, without public trial, without confrontation of the witnesses against him, without hearing witnesses in his favor, without defense, without counsel, is contrary to the provision also of the Constitution, is therefore not law, but utterly void and of no force. I wish we could just copy-paste that. Utterly void and of no force. Let's just paste that everywhere. That transferring the power of judging any person who is under the protection of the laws from the courts to the President of the United States, as is undertaken by the same act concerning aliens, is against the article of the Constitution which provides that, quote, the judicial power of the United States shall be vested in the courts, the judges of which shall hold their offices during good behavior, end quote. And that the said act is void for that reason also. And it is further to be noted that this transfer of judiciary power is to that magistrate of the general government who already possesses all the executive and a negative on all legislative powers. Number 7. Resolve, that the construction applied by the general government, as is evidenced by sundry of their proceedings, to those parts of the Constitution of the United States which delegate to Congress a power, quote, to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, and, quote, to make all laws which shall be necessary and proper for carrying into execution the powers vested by the Constitution in the government of the United States, or in any department or officer thereof, goes to the destruction of all limits prescribed to their powers by the Constitution. That words meant by the instrument to be subsidiary only to the execution of limited powers ought not to be so construed as themselves to give unlimited powers, nor a part to be so taken as to destroy the whole residue of that instrument. Highlight that part right now. I'm going to just to encourage you to do the exact same thing. Where do we want to start? To make all laws necessary and proper. We'll highlight all the way down to instrument. So next time you hear one of these individuals say, oh, well, what about the necessary and proper clause? What about the necessary and proper clause? That means Congress can do whatever necessary and proper. No, because as Thomas Jefferson perfectly explains here in less than a paragraph, in less than 4 sentences, he says actually, necessary and proper, if you read and finish that clause, it says the powers vested by the Constitution in the government of the United States. Necessary and proper, make all laws which shall be necessary and proper, does not create a new field in and of itself. It says you can do whatever is necessary and proper under the specific limits of the U.S. Constitution. You do not get this implied power for judicial review. You do not get this implied power to create Obamacare, to legalize homosexual unions. You don't get any of that power because it's not enumerated to you. It's not given to you expressly in the U.S. Constitution. And then pursuant to the preceding articles and in the Bill of Rights, whatever powers aren't directly enumerated to the U.S. government are retained by the states and the people. That's exactly what Jefferson is saying here. So because the federal government is not expressly given these powers, whatever actions it tries to take to impose them, to enforce them, to implement them, are of no law and are utterly void. That the proceedings of the general government under color of these articles will be a fit and necessary subject of revisal and correction at a time of greater tranquility, while those specified in the preceding resolutions call for immediate redress. 8th, resolved, that a committee of conference and correspondence be appointed who shall have in charge to communicate the preceding resolutions to the legislatures of the several states to assure them that this commonwealth continues in the same esteem of their friendship and union which it has manifested from that moment at which a common danger first suggested a common union, that it considers union for specified national purposes, and particularly to those specified in their late federal compact. Notice he says compact. Compact is a perfect or direct synonym of contract. Late federal compact to be friendly to the peace, happiness, and prosperity of all the states, that faithful to that compact according to the plain intent and meaning in which it was understood and acceded to by the several parties. Gosh, he is covering all bases, and it is excellent. It is sincerely anxious for its preservation, that it is also believed that to take from the states all the powers of self-government and transfer them to a general and consolidated government without regard to the special delegations and reservations solemnly agreed to in that compact is not for the peace, happiness, or prosperity of these states, and that therefore this commonwealth is determined, as it doubts not its co-states are, to submit to undelegated and consequently unlimited powers in no man or body of men on earth, that in cases of an abuse of the delegated powers, the members of the general government being chosen by the people, a change by the people would be the constitutional remedy. But where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy. Highlight that right now. Where the powers are not directly delegated, a nullification of the act is the rightful remedy. Take that to your state legislatures. Take that to your convention of delegates. This is the author of the U.S. Declaration of Independence. The most American thing you can do, and I say American in quotes because there's no such thing constitutionally, legally, politically as an American. In fact, calling yourself an American is probably the least American thing that you can do. Remember, Thomas Jefferson, James Madison, and George Washington, they all proclaimed to be Virginians, not Americans. They died as Virginians, not Americans. Take that to your state legislatures. Take that to your delegate conventions. A nullification of the act is the rightful remedy. Not treason, not sedition, not insurrection, not rebellion, not un-American, not unpatriotic, not, oh, you hate the Constitution, oh, you hate America. It is the rightful remedy, pursuant to the author of the U.S. Declaration of Independence. That every state has a natural right in cases not within the compact, casus non foederis, to nullify. I'm going to highlight that so I can remember to do a lecture on that. I've been meaning to, but then I, of course, let it skip my mind. to nullify of their own authority all assumptions of power by others within their limits, that without this right they would be under the dominion, absolute and unlimited, of whosoever might exercise this right of judgment for them. That nevertheless this commonwealth, from motives of regard and respect for its co-states, has wished to communicate with them on the subject, that with them alone it is proper to communicate, they alone being parties to the compact, and solely authorized to judge in the last resort of the powers exercised under it, Congress being not a party, but merely the creature of the compact. Oh man, imagine telling that to the modern day federal government. We are going to determine, the states are going to determine what's constitutional, and you can't. You're not even a party to that decision. You're not even a party to that determination. Back off. Imagine telling that to the federal government. Yeah. Congress being not a party, but merely the creature of the compact, and subject as to its assumptions of power to the final judgment of those by whom and for whose use itself and its powers were all created and modified, that if the acts be specified should stand, these conclusions would flow from them, that the general government may place any act they think proper on the list of crimes and punish it themselves, whether enumerated or non enumerated by the Constitution, as cognizable by them, that they may transfer its cognizance to the president or any other person who may himself be the accuser, counsel, judge, and jury, whose suspicions may be the evidence, his order the sentence, his officer the executioner, and his breast the sole record of the transaction. That a very numerous and valuable description of the inhabitants of these states being by this precedent reduced as outlaws to the absolute dominion of one man, and the barrier of the Constitution thus swept away from us all, no ramparts now remains against the passions and the powers of a majority in Congress to protect from a like exportation or other more grievous punishment the minority of the same body, the legislatures, judges, governors, and counselors of the states, nor their other peaceable inhabitants, who may venture to reclaim the constitutional rights and liberties of the states and people, or who, for other causes, good or bad, may be obnoxious to the views, or marked by the suspicions of the president, or be thought dangerous to his or their election or other interests, public or personal. That the friendless alien has indeed been selected as the safest subject of a first experiment. But the citizen will soon follow, or rather, has already followed. Remember that long-standing adage, give an inch, they take a mile. May start with aliens, but next will be citizens. They come for you, they'll come for me. Same principle here. Listen, ladies and gentlemen, there are very clear principles and tenets written into natural law, written into human behavior. What Jefferson is saying here in 1798 is just as prevalent today in 2025. But the citizen will soon follow, or rather has already followed, for already has a sedition act been marked him as its prey. That these and successive acts of the same character, unless arrested at the threshold, necessarily drive these states into revolution and blood, and will furnish new calumnies. I looked up how to pronounce that word, but I've forgotten it. Calumnies. We'll go with that. I don't think that's the correct pronunciation, but we'll go with that. Calumnies against Republican government. But I thought it was a democracy. No, Republican government. And new pretext for those who wish it to be believed that man cannot be governed but by a rod of iron. That it would be a dangerous delusion were a confidence in the men of our choice to silence our fears for the safety of our rights. That confidence is everywhere the parent of despotism. Free government is founded in jealousy and not in confidence. It is jealousy and not confidence which prescribes limited constitutions to bind down those whom we are obliged to trust with power. That our Constitution has accordingly fixed the limits to which and no further our confidence may go. And let the honest advocate of confidence read the Alien and Sedition Acts and say if the Constitution has not been wise in fixing limits to the government it created, and whether we should be wise in destroying those limits. Let him say what the government is, if it be not a tyranny which the men of our choice erred on our president, and the president of our choice has assented to and accepted over the friendly stranger to whom the mild spirit of our country and its law have pledged hospitality and protection. You can really tell Jefferson is getting ticked off at this point. That the men of our choice have more respected the bare suspicion of the president than the solid right of innocence, the claims of justification, the sacred force of truth, and the forms and substance of law and justice. The funny part is John Adams was the president during this time, during the Alien and Sedition Acts. In fact, he was the one that really pushed for them to be passed. And before the end of his life, Thomas Jefferson and John Adams were really good friends. So they are going to political war right here, but then by the end of their lives, they're tilling fields together. Not that intimate, but they were pretty good friends. In questions of powers, then let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution. That this Commonwealth does therefore call on its co-states for an expression of their sentiments on the acts concerning aliens and for the punishment of certain crimes, herein before specified, plainly declaring whether these acts are or are not authorized by the federal compact. Listen to that. Instead of appealing to SCOTUS, instead of appealing to the U.S. Supreme Court, Thomas Jefferson is saying, hey, here in Kentucky, we think this act from the federal government is bogus. Fellow states, co-states, what do y'all think? Let's be the arbiter. Let's be the determiner. Let's be the adjudicator of what is and what isn't constitutional. Don't appeal to the government. Don't appeal to the federal government, which the Constitution forms, because of course they're going to grant themselves more powers. Instead, rely on the states. It is brilliant. Herein before specified, plainly declaring whether these acts are or are not authorized by the federal compact. And it doubts not that their sense will be so announced as to prove their attachment unaltered to limited government, whether general, another typo, maybe a typo or might be a misspelling in the original document, whether general or particular, and that the rights and liberties of their coast states will be exposed to no dangers by remaining embarked in a common bottom with their own, that they will concur with this Commonwealth in considering the said acts as so palpably against the Constitution as to amount to an undisguised declaration that that compact is not meant to be the measure of the powers of the general government. Whoa! But that it will proceed in the exercise over these states and of all powers whatsoever. Brilliantly put. That they will view this as ceasing the rights of the states and consolidating them in the hands of the general government with the power assumed to bind the states, not merely as the cases made federal, cases federis, but in all cases whatsoever by laws made, not with their consent, but by others against their consent. That this would be to surrender the form of government we have chosen and live under, one deriving its powers from its own will. Highlight that part. This is brilliant. Great stuff. Its own will and not from our authority. And that the co-states, recurring to their natural right in cases not made federal, will concur in declaring these acts void and of no force, and will each take measures of its own for providing that neither these acts nor any others of the general government not plainly and intentionally authorized by the Constitution shall be exercised within their respective territories. Go ahead and highlight that whole paragraph there at the end. Excellently stated. Or I think it's a run-on sentence, but regardless, any acts from here forward. Amazing. And lastly, ninth resolved, that the said committee be authorized to communicate by writing or personal conference at any times or places whatever with any person or persons who may be appointed by any one or more co-states to correspond or confer with them, and that they lay their proceedings before the next session of assembly. Then here we have down here James Madison and the Virginia Resolution, but that'll be for another lecture. Ladies and gentlemen, it goes without any ambiguity. Thomas Jefferson, author of the actual founding document over the Union, or for the Union rather, overtly said, the states are the sovereign. The states are the ones who decide what is or what isn't constitutional. If you're going to call me a traitor, if you're going to call me treasonous, seditious, an insurrectionist, a rebel, a rebel, a rebel, I wasn't sure to say rebel or rebellion. If you're going to call me a rebel, you have to do the exact same thing to Thomas Jefferson, the man who authored the document which formed, not even just formed, provided the entire foundation for your government to exist, for your federal government to exist, for this general government to exist. If you do that, if you call that man a traitor, treasonous, seditious, an insurrectionist, a rebel, then I think it's less of I'm in the wrong place and you're in the wrong place. But that's an argument to be had for another day and hopefully in person. So, if you have any questions about what Mr. Jefferson was saying there in the Kentucky Resolution of 1798, if you have any questions or maybe a topic you'd like me to cover in a future lecture, go ahead and post those in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So if you have any questions at all, please post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, just like always, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.